Welcome. I'm Kerry Abrams, Dean of Duke Law School. I am pleased to be able to offer today's program, Policing in America. How did we get here and where do we go? Joining us today are members of the entire Duke Law community, including our students, many of whom are incoming first-year students, to whom we offer a special welcome. We are so pleased to have you joining with us today and in the fall. Our alumni, a vibrant and engaged group that sustains the Duke Law community, and of course, to members of our faculty and our staff. Duke Law's mission goes beyond simply educating students for responsible lives in the law in service to their clients and to their communities. Our mission is also to enhance the understanding of law and to improve the law. Our faculty's work informs legal systems and institutions nationally and internationally through research and scholarship of the highest caliber. Their work draws on the past, responds to the present, and informs our future. Today's program on areas of critical national importance unites these timeframes. While the issues around policing have taken on more urgency in the last few months, these issues are not new. Our program highlights the history of policing and related laws to help us understand how we got to this place, notes the legal recourse intended to protect rights and provide remedies when things go wrong, and discusses how change is made through new laws, internal policies, cultural shifts, and when necessary, citizen protests. The program is but a small part of the broader mission of these faculty members and our institution. The law school and university have hosted related programs in recent years, including a day-long Provost's Forum on policing. We will continue to bring the best scholars together to address the challenges faced by communities around the country. In the meantime, our aim is to contribute critical voices and understanding to the dialogue. We hope you will find the program helpful. We are recording it and will make it available on our website and our YouTube channel. You will be able to submit questions through the Q&A links at the bottom of your screen, and we will leave time at the end to address as many of these questions as we can. Before the beginning of the program, I want to thank several people who helped to make this happen. Thank you to Rachel Greason, Bethan Einan, Miguel Bordeaux, and Caitlin Shaw for their work in planning the program. And a special thanks to Stella Boswell, Assistant Dean for Public Interest and Pro Bono, who did much of the conceptual labor of designing this program, choosing panelists, and shaping the scope of our conversation. Thank you so much, Dean Boswell, for your vision and dedication to these important issues. Now, I would like to welcome today's moderator, J. Hamilton McCoy II, known to friends and colleagues as Jesse. Professor McCoy is a senior lecturing fellow at Duke Law School and serves as the supervising attorney in our civil justice clinic. His work focuses on housing, inequality, and eviction issues, which are social issues that also fall underneath the umbrella of civil rights. Professor McCoy is a passionate teacher and actively engaged in the community. As a member of our clinical faculty, he supervises students as they provide critical legal assistance to clients who cannot afford to hire a lawyer. He also co-teaches a social justice lawyering class and draws on his personal experiences growing up in Durham to inform his teaching. We are fortunate to have him as our moderator today. Welcome, Professor McCoy.
Thank you, Dean Abrams. I'm so glad to be a part of today's program. These issues are critical. They have personally impacted me and other members of the Duke Law community. So if they resonate with you, know that you are not alone. I'm also aware that our students and our alumni have engaged on all sides of these issues in classes, internships, courtrooms, and some very recent events in the streets protesting. Today's program allows us to frame those thoughts through the lens of the law and through our collective history. I hope it will allow each of us to contribute to greater dialogue and understanding around these topics, as well as address some of the ways in which the law may be insufficient or the legal process may be inadequate. I'm going to do a brief introduction so that we can jump right into the conversation and leave time for questions and discussion at the end. So let's meet our panel. First, we have Professor Brandon L. Garrett. And he is the L. Neil Williams Professor of Law at Duke University School of Law, where he has taught since 2018. He is the founder and faculty director of the Center for Science and Justice here at Duke, which does research and policy work to reform the criminal system. Before he became a law professor, he was a civil rights lawyer focusing on police misconduct cases. More recently, he has been an American Law Institute reporter on the Principles of Policing project, and with his colleagues on that project, released a report on how to reform policing. Professor Lisa Kern Griffin is the Candace M. Carroll and Leonard Simon Professor of Law. Professor Griffin's scholarship focuses on evidence theory, constitutional criminal procedure, and federal criminal justice. Her recent work concerns the status and significance of silence in criminal investigations, the relationship between constructing narratives and achieving factual accuracy in the courtroom, and the criminalization of dishonesty in legal institutions and the political process, as well as the impact of popular culture about the criminal justice system. Professor Griffin's book, Lying, Truth-Seeking, and the Law of Questioning, is forthcoming from Cambridge University Press. In addition to numerous academic articles and book chapters, her opinion essays have appeared in popular outlets, including The Atlantic, Slate, and the New York Times. Next, we have Professor H. Timothy Lovelace, a noted legal historian of the civil rights movement. He recently joined the Duke Law faculty. Professor Lovelace teaches American legal history, constitutional law, and race in the law. His work examines how the civil rights movement in the United States helped to shape international human rights law. He has published many journal articles. His forthcoming book, The World is on Our Side, the US and the UN Race Convention, examines how United States civil rights politics shaped the development of the International Convention on the Elimination of All Forms of Racial Discrimination. Professor Darrell A.H. Miller is the Melvin G. Shimm Professor of Law. Professor Miller writes and teaches in the areas of civil rights, constitutional law, civil procedure, state and local government law, and legal history. Professor Miller's scholarship on the Second and 13th Amendment has been published in leading law reviews and has been cited by the Supreme Court of the United States, other federal courts, and in congressional testimony. With Professor Joseph Blocher, he's the author of The Positive Second Amendment, Rights, Regulation, and the Future of Heller. Thank you all for participating in this panel and for making time to address what is currently such an important and socially relevant issue. Given the breadth of your expertise, I know that we may not answer all of the questions that people may have, but we will do our best to address as much as we can in the time allotted. We know that many attendees will have to sign off at 1 o'clock, but we are open to continuing to 1:30 if the questions continue. Attendees can submit their questions via the question and answer feature on Zoom, and we will get to as many questions as we can at the end of this program. I was wondering if each of you could start by giving us a brief understanding of your scholarship and teaching to frame our conversation and to note what has failed or brought us to this moment in time. So beginning with Professor Lovelace, what is your expertise in the civil rights movement, particularly of those movements in the 1960s, and how have the social movements of the 1960s influenced where we are as a society today?
So thank you so much for the introductions, and I'm very grateful to the organizers of this event and my fellow panelists. I'm a legal historian of the civil rights movement, and we're having this conversation today because a social movement is forcing Americans, and indeed many people across the world, to rethink policing. This is a fascinating time for me as a legal historian because activists are using history to frame contemporary debates around law and policy. People are in the streets asking their friends, their supporters, even those that they oppose, what side of history will you be on? Right? How will history judge your actions, that remembering the past has transformed into a way to spur Americans into doing something that they might not ordinarily do: protest police violence during a pandemic. And so today's activists often see themselves as heirs of a social movement that occurred during the 1960s. Their movement repertoire draws heavily from the civil rights movement in particular. The signs that they carry, the t-shirts that they wear, the freedom songs that they sing all draw from the civil rights movement. The organizers study organizational models and leadership styles of the 1960s. They, for example, draw from people like Ella Baker, who helped to found the Student Nonviolent Coordinating Committee 60 years ago in Raleigh, North Carolina at Shaw University. SNCC, as you may know, was headed by John Lewis, and they had these very robust ideas about participatory democracy. And Black Lives Matter, no doubt, draws from SNCC. Today's activists, also like those in the past, are really interested in using media and using new media to shape public perceptions around police violence and more broadly systemic racism. In the 1950s and 1960s, the AP wire, the UPI wire, they were crisscrossing the world. TV in the 1950s and 60s was new media. And so activists like Dr. King or members of SNCC skillfully mobilized new media of their time to dramatize their plight. Today's activists are taking a page from, no doubt, the civil rights movement. Right? So they're using new media, Twitter, Facebook, Instagram, right, their cell phones to circulate images of police brutality and then of protests. But more so than anything else, and I think that this is a really critical point for our discussions today, today's protesters, like those of the past, have a profound understanding of the relationship between law and social movements, right? That protests have the power to help remake law. And so for the protesters today, right, they look back at the 1960s and they see that protests helped to create the political context for social change, legal change, political change. And that these activists during the 1960s were incredibly frustrated with the slow pace of racial reform and the promises of racial reform that never materialized. And so when the traditional forms of redress were ineffective, they turned to the streets. They sought redress in the streets. They protested in places like Birmingham and Atlanta, and that helped to create the political context for passing the Civil Rights Act of 1964. They protested in Selma, Alabama, and that helped to create the political context for passing the Voting Rights Act of 1965. They protested after the assassination of Dr. King, and that helped to create the political context for the passage of the Fair Housing Act of 1968. And so people in 2020 have turned to the streets because they are too frustrated with seeing video after video of police brutality. They're frustrated by police reforms that never materialize and that there's a slow pace of change. Bias trainings have not been enough to end police brutality and racial profiling. Increased or calls for increased police discipline, right, have been often ineffective. Lawsuits and settlements for cases of police misconduct have been unable to end police violence. And in fact, settlements have often become a budget line for many police departments. And when officers face credible accusations of unlawful conduct, these officers are regularly not indicted, and even when they are tried, they are rarely convicted. This is the last point that I'll emphasize here as I think about the relationships between the past and the present, is that the past is not always so far away. Nearly 4 years ago to the day, we were having a similar kind of conversation about policing, right? In policing, we've talked about George Floyd in Minnesota. We have to remember Philando Castile, right, who was shot by officers in front of his partner and 4-year-old daughter. Activists are tired of story after story, video after video, discussing reforms through traditional modes of change. And so they take it to the streets like people in the 1960s. And so they have deep frustration, but they also have an abiding hope that America can indeed become a better place.
Thank you for that. Professor Miller, one of your areas of expertise is policing and related civil rights litigation. How did policing in the United States begin, and what role has race and civil litigation played in addressing police misconduct?
Yeah, thanks, Professor McCoy, and thanks again to the organizers for this. So when I think about this issue, I make a distinction between the police and policing. The police, the idea of a professionalized, politically accountable, trained force that is dedicated to enforcing the law and keeping the peace is really a mid-19th century invention. There was no such thing prior to the mid-19th century in America. Instead, policing, the activity of law enforcement and keeping the peace, is much, much older and actually comes from Europe, mostly England. And from the colonial days to the mid-19th century, policing was a kind of community-based activity. And I say community in the very loose sense because the people that did the policing were predominantly, if not overwhelmingly, just white men. And so in this period of policing, what you would have would be if there was a suspected crime, somebody would go to the sheriff or the local magistrate in the city, and they would literally form a posse. The thing that you hear about on television or in movies about forming a posse is a real thing, a real way about how law was enforced prior to the professionalization of the police department. People would be called out with their own private arms, private citizens in the community. They would be deputized by some kind of action of law, and they would go and hunt down the suspected perpetrators. Now, you can imagine, surprisingly, then this way of policing is subject to being a tool of racist oppression against persons of color. And I think it's possible that this, and it's proven that this happened in two ways. The way that oppressors always use law enforcement as a tool of oppression. They either punish the innocent or they protect the guilty. So punishing the innocent, anybody that is even passingly familiar with the history of lynching and vigilante violence in America would know that if, in fact, this posse got together and there was a suspect of some actual or pretended crime committed by an African American, then if the posse didn't find the actual suspect, any old Black person in the community would do, because the purpose was not to punish the guilty. It was really about control of the Black populace within the vicinity. The second way, again, that law enforcement can be used and has been used as a tool of oppression is to protect the guilty. So the white mill owner who is upset about having a competitor in the Black mill owner in the vicinity gets all his employees and buddies to go and burn the place down. The African American says, you know, I know exactly who did it, and there is no law enforcement apparatus, either professionalized or public, that is willing to actually punish the guilty. And so we have to recognize that the tool of oppression here is both partial enforcement and partial lack of enforcement of the law. Now, two things during Reconstruction were supposed to resolve this. One was the passage of the 14th Amendment, which expressly has an equal protection clause. It's equal protection of the law. And the second was a piece of legislation during Reconstruction that was meant to enforce the 14th Amendment. It is called the Ku Klux Klan Act. It was passed in 1871, and it is the direct progenitor of our modern tool 42 USC section 1983 that's used to bring private litigation against police departments, against cities, and against individual police officers when they commit police misconduct or police violence. Now, this has not been as an effective tool as it could be for, I think, at least 4 reasons. The first is something about peculiar to 1983 itself, which is unlike other forms of torts, there's not what's known as vicarious or respondeat superior liability. So if you are hit by a Coca-Cola truck driver, you can sue Coca-Cola for the actions of the driver of the Coca-Cola truck. 1983 does not work that way. You can't sue the city for the actions of the individual police officer, and this creates a disincentive, at least directly, for the city to make sure that its police department is behaving properly. The second problem is something called qualified immunity. So even if you sue the officer directly, qualified immunity is sometimes an insuperable barrier to relief for persons that are victims of police violence. What started out as a sort of good faith exception, that is trying to give police officers a break when they make a reasonable mistake, has expanded so that in some jurisdictions it's known as unqualified immunity. No matter how egregious the conduct, no matter how wicked the behavior, the police officer is not found to be liable. The third impediment to using 1983, this Ku Klux Klan Act, is certain kinds of procedural challenges in litigation. It's very hard to do structural litigation against police departments in a case-by-case basis. It can happen. The success of litigation against stop and frisk in New York City is an example, but it's an example that kind of proves the rule, how difficult it is to use case-by-case litigation to actually administer justice in terms of reforming police departments. And the fourth thing is that private litigation is really bad at this other kind of problem of using law enforcement to protect the guilty. That is, just this week, an African-American woman and her daughter in Raleigh were threatened by 2 white men with a private firearm in a truck. And they called the police, and there really is not a mechanism in 1983 if the police just never decide to show up because, for whatever reason, to actually address that kind of oppression. So today what we have is a law enforcement system that is very, very disturbing, very troubled, and the tools of private litigation that are used to make law enforcement do what it's supposed to do, which is to punish the guilty and protect the innocent, are not working as they should.
Thank you for that. Professor Griffin, one of your areas of expertise is constitutional criminal procedure. How does the law influence police interactions with citizens and communities, especially as it relates to communities of color?
Thank you, and welcome everyone. I'm glad to have the chance to talk to you about this urgent topic. And the answer to your question is that the law leaves communities of color exposed to police violence. Police force is state-sanctioned violence. It's the most threatening and damaging thing that the government has the power to do to citizens. But constitutional regulation of the police is very attenuated and lately has been very ineffectual. The early Supreme Court decisions expanding criminal procedure protections are civil rights cases. Many of them were inspired by the need to discipline the southern states for racialized brutality by the police and for gross inequities in the criminal courts. But since then, there has been very little evolution in these rights and in fact, significant contraction of them, which means that what the law is doing is creating permission structures for police officers, which become pathways to violence. George Floyd's murder is a crime by the police, but I want to talk for a minute about legal police violence. There are a lot of steps in these encounters before the knee is on the victim's neck. Why were they there in the first place? What about the legal discrimination that is taking place in police forces and what I've sometimes called procedural violence? Criminal procedure sets the boundaries for when police can stop people, search them, arrest them, and that's where the opportunity for violence comes from. That's why citizens don't feel safe just moving freely through the world. There are about 1,000 police killings every year, but there are tens of millions of police-citizen encounters that give rise to those incidents. And it turns out that police can stop people for almost any reason at all because of the deep, unexamined discretion that officers have to profile and pull people over or otherwise detain them, because of the shallow suspicion that's required to conduct frisks and car searches when they do, and because of the incredible speed with which encounters can escalate because officers decide to make an arrest based on some outstanding warrant for a minor offense. I'll give you two examples of the enormity of this problem that also point to some potential for change. Traffic stops are the most common police-citizen encounter. There are 250 million cars in this country. There are 50,000 drivers who are pulled over every day, 20 million a year, half of all the encounters that citizens have with police officers. In fewer than 10% of those stops is any sort of evidence or contraband observed, and fewer than 1% of them lead to arrests. But they're the moments when these encounters begin. For example, there are 11 million suspended licenses for things like unpaid debts around traffic tickets. So there's a good chance that whenever law enforcement is curious about a driver for any reason, they can pull them over. And the Supreme Court has ignored the fact that this is racially biased decision-making by the police. Even if a stop is actually motivated by stereotypes, the Supreme Court has expressly said that it will ask no questions as long as there is some later claim that there might have been another reason. The 1996 Wren case prevents litigation about the actual motivations of police officers. And one of the simplest and easiest things that we could do to put a stop to that is to disaggregate traffic safety from drug interdiction. Most of these stops, almost all of these stops, have nothing to do with the safety of the roads. They are investigative activity by law enforcement, and there's no need for those two things to be happening at the same time. The second example is pedestrian stops and frisks, what are sometimes known as Terry stops. Professor Miller mentioned the litigation, the class action litigation surrounding the use of these stops in New York City. At the height of this practice, around 2011, there were 700,000 of these stops a year. And in many districts, 90% of those stops were of Blacks and Latinos. After the litigation, when they cut down substantially on the number of stops and frisks that they were doing, there was zero increase in crime in New York City. And the reason that these stops were occurring and persist across the country is because they only have to be based, according to the Terry Doctrine, on reasonable suspicion. And reasonable suspicion is a racialized standard. It allows police officers to account for things like the way people are dressed, the neighborhood in which they are found, what they presume to be drug activity, or the perception that someone is trying to evade the police. It's just based on common sense, and what the police consider their common sense is often race-based.
Thank you for that. Professor Garrett, what accounts for longstanding racial disparities in policing?
Hello, everyone. Thank you, Dean Abrams. Thank you, Professor McCoy. Thank you, Assistant Dean Boswell and my colleagues on this panel. It's wonderful to have a chance to discuss these urgent, pressing questions with all of you and our Duke Law community. And thank you in advance for your questions. I see several have been posted already. I want to echo what my colleagues have said. Today's activists, lawyers, policymakers, and also our policing leaders understand well that the problem of policing in America and the problem of racial bias in policing in America is deep-rooted and legal recourse is lacking. Police in America have incredibly broad discretion, to stop people, to make arrests, and to use deadly force. About 1,000 people are killed each year by police, and it's remarkable that police violence is a leading cause of death for Black men in particular. This is a public health and a civil rights crisis as much as it is a policing crisis. As Jesse mentioned, I became a civil rights lawyer because I wanted to work on policing cases. And many of those cases were not just cases involving deadly force used against civilians. That's just the tip of the iceberg. In one case that went to trial, it was a Black police officer who was shot while intervening at a scene, shot by fellow officers. In another case, it was a young man who was punched repeatedly in the eye because of a dispute in line at the post office with a police officer. In another case, a young man was shot and suffered grievous non-fatal injuries while being dragged by an officer through the window of a cruiser. And one of the things that made me want to be a lawyer as a law student, I worked on class action litigation against the street crimes unit of the NYPD to the stop and frisks of millions of young minority New Yorkers that Professor Griffin just mentioned. Also worked on a series of suits that were not about force, but about wrongful convictions, which are also highly racially disparate. The vast majority of those who have been exonerated by DNA testing are Black and Latino men. Last fall, we launched the new Center for Science and Justice at Duke with a former client of mine, Yusef Salaam, who was one of the exonerated 5. His case was featured in When They See Us, the Netflix documentary. Some of these lawsuits were successful, but by no means all of them were, and even the ones that were took a very, very long time in the federal courts. You know, back when I was a law student, I worked on the stop and frisk class action litigation. That was 1998 and 1999. That litigation went on until 2005, and then the lawsuit was resurrected with a second class action, the Floyd case, because the practice has continued. And the Floyd litigation is ongoing to this day. There are more recent motion practice regarding disparate enforcement under COVID by the New York City Police Department. The exonerated 5 wrongful conviction lawsuit, I worked on it back in 2002 before I was a law professor, didn't settle until 2014. Apart from these delays, the law is unfavorable. I wanted to talk not about qualified immunity and the civil rights statutes themselves, but about Fourth Amendment law. So the US Supreme Court in its 1989 ruling in Graham versus Connor has said that officers may react to potentially deadly threats basically based on what seems reasonable in the moment. Officers then benefit from a second layer of court-made deference in the form of qualified immunity. I also teach habeas corpus, and the Supreme Court has said similar things regarding deference when cases are challenged after a criminal conviction. What this endorses is multiple layers of reasonableness-based deference to discretionary decisions by law enforcement. This shoot-from-the-hip approach endorsed by the Supreme Court has led to Black suspects being far more likely to be killed by police, but also wrongly convicted, arrested. Officers' lack of familiarity with the community or their cognitive biases may cause them to jump to deadly and wrong conclusions. We saw that in the case of George Floyd, who posed no risk to anyone. We saw that in the case of Tamir Rice, who had a toy gun when shot in Cleveland. But this problem extends more broadly to policing agencies as institutions, and it extends to what we ask police to do, which is not just on the police, but it's on us and our communities and our leaders. It extends to decisions that we ask police to make, whether to stop, arrest, respond to community calls. At our Center for Science and Justice, we've documented racial disparities in things like life sentences, death sentences, use of force, but also use of traffic tickets, which, like Professor Griffin mentioned, is the #1 source for interaction between police and the community, traffic enforcement. Criminal debt in a range of petty cases. And this is not just a policing problem. We should not be asking police to use their tools, which are blunt and can come with force, stops, frisks, arrests, to respond to public health, behavioral health, to the current pandemic, to poverty, and to homelessness. Wholesale change is long overdue, and it must begin with our conception of what work we want police to do in the community.
Thank you for that. Across the nation and even across the globe, people have taken to the streets to protest policing policies through the Black Lives Matter movement and numerous other community-based social justice organizations. Professor Lovelace, how is the current movement unique? What can the movement do to create significant and lasting change? And how should the success of this social justice movement be measured?
So one of the things that's really striking about this particular moment and why it is unique, just simply the scope and the scale of these protests. Literally tens of millions of Americans have participated in these protests, and they've participated in these protests every day since George Floyd's murder. And the protests have occurred in places like New York, Chicago, and LA, places that you might think of as places for protests outside of Minneapolis. But these protests have also occurred in suburbia, in rural areas. And that should give us a lot of hope about change for the future. The leadership and the participation in these movements is also just something very different than what we've seen in the past. Black Lives Matter was founded by Black women, and Black women serve as leaders in many of the local movements. There are very large numbers of participants in these marches who are not African American. This is something very different than what we saw in the 1950s and 60s. Here we have the ability to form a multiracial coalition around anti-Black racism. This is hope. This gives me hope for great change. Social media, right? So I talked a bit about media in the past, but social media has really just changed the dynamics around the police and, to Professor Miller's point, policing, right? So individuals are able to film police interactions far more frequently, and then to record those who are citizens who are participating in a policing function in a discriminatory fashion. The political context for these protests have changed. I think that while there are a number of local and state officials that have been instrumental for pushing forward the conversation, at the federal level in particular, we see great changes and changes from the context that we saw that inspired the passage of the Civil Rights Act of '64, the Voting Rights Act of '65, and the Fair Housing Act in '68. Just plainly, we have a white nationalist who is our president, and Congress is more polarized than perhaps more than definitely in the 1960s. People are also protesting during a pandemic. On one hand, there's great peril here. People are literally risking their lives for the cause of social justice. And this too gives me, in many ways, great hope that it means so much to everyday citizens to get out in the streets, that they would put their bodies on the line to advance the cause of justice. The reforms themselves are also different. The word abolitionism, as it relates at least to policing, was not in the vocabulary of many Americans before a couple of weeks ago. Same with the term defunding the police. And this is what social movements do. They give us a new vocabulary to talk about legal and social change. I'll take the last two portions of your question together. How do we think about and measure success? And then how do we enact longstanding change? The first part of that question, I think that we should measure success from a social movement perspective. You have people who are protesting, who are transforming their lives for themselves. They're not waiting for a racial savior, a king, right, to come in and save the day. They're getting out in the streets, they're protesting, they're starting new organizations. They're joining old organizations and revitalizing those organizations. Their rights consciousness has also changed. We started this conversation around policing. We've now broadened the conversation to talk about systemic racism, again, another term that many Americans were not using a couple of weeks ago. The final point is this. We can measure success through lasting change in law and in politics. It's imperative to vote and to participate in the political process, not simply at the federal level, but also at the local level and at the state level. And there must be new pushes for new legislation around policing in particular, that we might also in this process, think about state government and local government as sites for change. And policing goes directly to this point. Much of policing is controlled by state and local government. And so I think that there is, again, great hope for change. I'm hopeful, and I think that if we put our faith to work, it can be done.
Professor Miller, what do you see as being the most significant issues in policing and private policing today? And what can be done to address those issues?
So building on the themes from my previous remarks, I think that when we think about the problem of racial injustice, we need to think beyond just the police and think about the activity of policing. So George Floyd and Ahmaud Arbery were both killed by racist policing within a few weeks of each other. But only one was killed by the police. Arbery was killed just like Trayvon Martin many years ago was killed by a private citizen who had been empowered by state law to take deadly weapons and take it upon themselves to perform a policing function. So if we think about this as only a problem with the police, we're only addressing half the picture here. And we're potentially leaving unaddressed a vast and potentially explosive problem when we think of it as just a police problem as opposed to a policing problem. There are 300 million guns in private hands in the United States. Half the states allow individuals to carry these weapons with absolutely no training on how to use them. A majority of states have what are known as stand your ground laws that allow individuals who feel threatened based on their own threat assessments, which we know to be racially inflected, to take deadly aim at individuals and kill them. And in states like Florida, the presumption is that the killing was lawful unless it's proved that it's not. This is a part of an entire spectrum of what we might think of as policing. And so when I think about this issue, what I really think is we have to think about it globally, not as a problem just with the police, but with a problem with policing. That is, we need to make all use of force by individuals who feel empowered to do law enforcement, to do it in such a way that it is safer, more equitable, less racist, and better for all communities.
Professor Griffin, what are the most significant legal issues that contribute to escalation in interactions? What would you suggest for reform?
So there are two things. One that seems small but is enormous, and one that is undoubtedly enormous but that we all have to confront. The first, the thing that seems small, is the proliferation of justifications for stopping people and for making arrests. This is an area of the law that can change. It's an act of utter hopelessness to suggest that it just has to be this way. We don't have to have pretextual traffic stops and unsubstantiated suspicion and broad authority to make arrests. We don't have to have no-knock warrants either. These are things that are mutable and that can be addressed. For example, the proliferation of misdemeanors, the explosion in misdemeanor offenses, including fine-only misdemeanor offenses like a seatbelt violation in one well-known case called Atwater, is allowing police to make arrests, which then often escalate encounters into violence. Police can make arrests for this category of offenses that is sometimes referred to as contempt of cop. And it has to do with obstruction, resisting. In theory, individuals are free to challenge police without risking arrest. The Supreme Court has overturned ordinances that criminalize things like swearing at the police on First Amendment grounds. But none of that law helps very much when the court is not willing to examine the real reasons why police are stopping and arresting people and the existence of good or bad faith. The other proliferation problem is warrants. There are millions, 8 million outstanding warrants, and every single one of them justifies a traffic stop and ultimately the arrest often of someone the police choose to encounter. So even if a stop is bad under these very low standards that I described earlier, since a 2016 case called Utah versus Streep, the police can cure a bad stop if they later discover an outstanding warrant. But in some communities, there are as many outstanding warrants as there are adult residents. And this led Justice Sotomayor in her dissent in that case to say that the mere existence of a warrant gives an officer legal cause to arrest and search a person and forgives an officer who, with no knowledge of the warrant at all, unlawfully stops a person on a whim or a hunch. As she concluded in her breathtaking dissent in that case, everyone is now not a citizen of a democracy, but the subject of a carceral state just waiting to be cataloged. And the enormous and difficult thing that I referenced is that the courts are going to have to be willing to do the same thing that our community and every institution has to do, which is be willing to explicitly identify the connections between race and violence. The police are a mirror in some respects of other social and political problems. But when the courts talk about the police, they never, ever talk about race. In all of the Supreme Court decisions about criminal procedure, there is a footnote in the Terry opinion. There's one majority opinion that addresses at all the issue of race. The justices live in a world in which Black males who are stopped on the street can decline to answer, can go on their way if they choose to do that. They've repeatedly said that people are free to disregard the police and go about their business. And there is what Justice Souter once called an air of unreality about all of that. So I think that the courts are going to have to be willing to do the hard work of seeing the connections that I've been talking about today. And there is one justice who has been doing so consistently, and that is Justice Sotomayor. So I want to just say what she said in her dissent in the Streif case, which is that it is no secret that people of color are disproportionate victims of this type of scrutiny. And we must not pretend that the countless people who are routinely targeted by police are isolated. They are the canaries in the coal mine whose deaths, civil and literal, warn us that no one can breathe in this atmosphere. They are the ones who recognize that unlawful police stops corrode all of our civil liberties and threaten all of our lives. Until their voices matter too, our justice system will continue to be anything but.
It's a great quote. Professor Garrett, what is happening with the efforts to reform how law enforcement works, and what is most promising?
Thank you all so much. I wanted to end by talking a little bit about where we go from here. Traditionally, we've been really reluctant to regulate police as institutions in any meaningful way. There are very few laws that regulate police. If you look at state codes, often they just generically define broad police powers, but there are very few laws that specify rules that police need to follow. With one exception, often DUI often has detailed rules because in that area, plenty of wealthy middle-class people get stopped and assert their rights. Instead, police have their own policies in patrol guides and the like, which are often not public and traditionally not based on any community or expert input. The exceptions around the country have been agencies sued by the Department of Justice, where you can have elaborate consent decrees, monitoring, and oversight. However, those consent decrees have been wound down and new consent decrees have not been entered by the Justice Department under the current administration. And there are only so many agencies that the Department of Justice can get involved when around the country. And we have many, many thousands of policing agencies in this country. We've had many dozens subjected to these detailed consent decrees. No healthy arm of government or of industry works that way, where something of immense public importance and entity that engages with so many people on topics that intersect so powerfully with our liberty and our civil rights and our health and safety is so almost entirely unregulated. Furthermore, although we've talked about how, to what degree the Supreme Court has given just blanket discretion to police officers, how deregulatory the Constitution has been in terms of criminal procedure, whether we're talking about arrests or deadly force. Police, just like any government agency, can do more and must do more than the bare minimum that the Constitution requires. Police can themselves define what force is reasonable or permissible. They don't have to just adopt the bare minimum Supreme Court endorsed standard. And to do that, officers need a new toolkit. It's not fair to police officers to tell them to just go out in the community armed, potentially confronting armed people, and just go with their gut and react in the moment. Doing so endangers the lives of members of the public, and it endangers their lives too. Nor are written policies enough. There's been much discussion of 8 can't wait or other elements of a good use of force policy, but everyone acknowledges in the policing community and the activist community that a paper policy is not enough. It's important to change the culture in policing, and to do that, you need to change training and you need to change supervision. Part of supervision is internal discipline. Will officers get disciplined, potentially even fired for egregiously violating policies? This has to change. And what makes this an exciting time is that, in part because of the incredible work that activists and protesters have done, these protest movements are the largest in our history, that there is an enormous momentum behind change. There's great work for law students to do. Law students at my center have been tracking legislation. There are over 60 bills regulating policing that have been introduced at the state and federal level in this country, most of which were introduced post-Floyd, just in the last month or so. And that's remarkable. I mean, traditionally in state houses, it was understood that you don't introduce legislation about policing. That's any bill having to do with police would be a dead letter. A joint statement by our center at Duke and with others, including collaborators on the American Law Institute project, Principles of Policing, set out a Changing the Law to Change Policing report, and we outline a range of changes that are important. Some of them are federal level changes, and the federal government does a lot of funding that goes to police departments that can improve best practices. The federal government can play an important role in setting standards. There are no national use of force standards. There are consent decrees here and there that the Department of Justice has entered, but there's no national accreditation, there are no national standards. It's left to individual agencies to come up with their own rules. You need national data collection on topics like police misconduct, like decertification. If you have an officer that is fired for serious misconduct, what record is there of that when they seek to apply for a job at another agency down the road or in another state? As our colleague Ben Grunwald has written, there's a serious problem of wandering officers that can easily be rehired because there's no centralized place to record that they were decertified or engaged in misconduct. There has been very little role traditionally, though, for regulation at the state and local level. And given how decentralized policing is in this country, there's a lot of work to do in everyone's community and in everyone's state. A lot of the reform lawsuits have been filed in federal court and by the Department of Justice. We need to empower state attorneys general to take action. And we need states to step in and make sure that use of force policies and practices are public and are sound and follow best practices. We need states to track police use of force and not just deadly force. We need states to track information about arrests, about fines and fees, traffic stops, all this low-level enforcement, which has an enormous impact on people's lives. So little in policing is meaningfully tracked, but once it's tracked, then there's a role for us just to step in and say, these levels of activity are not okay. These impacts on communities are not okay. This is what we want police to be doing. And, policing organizations are hierarchical and professional, and they, respond to rules and to instructions. We need to be defining what role we want police to follow. And providing better practices, better guidance, and a clearer role for policing is important for police officers to succeed. We need to define the terms of their success. Again, this is an incredibly exciting moment in our country, with protest movements that have been the largest in our history, and they're not going to stop because the problem isn't going away. To make this reform movement lasting, there's equally important and exciting work for lawyers to do. And I hope that all of you have taken from this conversation ideas, plans for what you might do potentially in your careers to contribute to this movement and to contribute to the lawmaking that can really reshape the future of policing in this country. So thank you all so much. I look forward to your questions and look forward to continuing these conversations in the months ahead.
All right, so during registration for this event and during this recording, we've allowed the audience to submit questions. What we received ran the spectrum from questions that were rooted in legal analysis, as well as more practical concerns that some of our students have given past negative experiences with policing. So I'd like to ask the panel a few of these questions, and whoever is most comfortable addressing the question, please feel free to provide your answer. It looks like the first question submitted by the audience is, how do we not lose police safety protection in all of this, which all communities, especially impoverished communities, need? Anybody taking a crack at that one?
Brandon, do you want to try?
Sure. I wasn't sure who wanted to go first, and since I was just talking, I didn't want to jump in right away, but the intersection between policing, race, and poverty has been longstanding in this country. And, we've never asked police to think about what impact are they having on poverty, what impact are they having on people's economic, social well-being. We've talked a little bit today about the impact of fines and fees and debt that comes out of policing. We haven't talked about bail, but we have enormous numbers of people in this country who are in jail, and now that's a potentially deadly situation given the spread of COVID, because they lack the financial means to pay cash bail. It's important to recognize that some of these economic impacts are not fully within the control of police. And we need to not be placing police in the position of debt collectors. Police may issue a traffic ticket because they believe someone was violating traffic laws. They may themselves not fully realize that that ticket is not set at a level that a person can pay, that a judge may not be able to excuse the cost of the ticket just because the person is indigent, and that the result may be that the person loses their license, loses their employment, with rippling economic effects, that the person may then be subject to arrest and jail time because of driving with a suspended license. All those additional economic consequences may be out of the control of the police officer that thinks that they're just issuing a ticket. And same thing in arrest. The police officer has no control over the fact that the person may subsequently spend weeks in jail because they can't make cash bail. That system in the courts may be very much out of the control of police. And in the past, they often didn't take into account these follow-on economic consequences when they made their policing decisions. And that's changed. There's now an economic justice conversation around why we do policing the way we do. But lawmakers have increasingly relied on police as a revenue source, and the most regressive revenue source possible. And police need to stand up. We all need to stand up to make sure that we don't place either our police officers or our courts in the position of being debt collectors.
So I'll just briefly chime in on what Brandon said. So, I think the premise here is that what we want the police to be not a threat to the community, but responsive to the community, that they want to be an asset to the community not an impediment to that community's development, growth, and sense of safety. And so, the question is really about, how do we not lose police? I don't think it's a binary. I think the premise here is that we want to make policing, less lethal and more about the purpose of professionalizing police services, which was as public service.
I'll tag in just very briefly. My comments, I agree, Professor Miller and Professor Garrett here. All Americans really do want public safety. I think part of the issue is that we're asking actually police officers to do too much, right? That police officers are being asked to deal with issues like homelessness, and there might be experts who are better positioned to deal with issues of homelessness or mental illness, et cetera. I think that part of the other issue is that, can we imagine a world where we are less reliant on police as we think about them now? Right? What systems would we need in place to prevent so much contact with police, right? So how might we think about education just very differently? And police officers within schools, how might we think about issues of poverty or mental health? And so that people don't get into the criminal justice system. And so I think that that's part of the kind of social imagination that you see emerging from these protests.
And just a point for the audience, I understand that some people will have to leave at 1 o'clock. We plan to continue the recording on up until 1:30, and we're going to provide that recording link. So don't feel like you've missed anything. If you have to go, we're gonna make sure that you get it. The next question I wanted to ask is to all the panelists, what do you feel is the best recourse for ultimately addressing and ending police brutality, and how can law students and lawyers engage in these efforts?
I'll start because I want to say especially to the students that though this is a time of grief and trauma and frustration, I hope some of the things that we've said suggest as well that it is an optimistic moment because of the convergence of willingness, of urgency, because finally many of these issues are coming to the fore. There's even sort of bipartisan consensus on some of the most important issues. So the things that matter, the things that you can do are in two categories, as citizens and as lawyers. As citizens, I think Professor Lovelace has made it very clear, protests matter. Taking to the streets makes a huge difference. That's what moved the needle here. And what impacted Justice Sotomayor to say what she said in the opinion that I read was Ferguson. She got those ideas from the Ferguson report. So sometimes these things evolve over a period of time, but they do penetrate. A lot of the progressive prosecutors who've been elected in recent years were arrested sort of in the wake of Ferguson and the original Black Lives Matter protests. And so these movements matter, and the citizenry matters, and politics matter as well. As Professor Garrett's been saying, there are 18,000 law enforcement agencies, not enough centralized oversight or even data about them. There hasn't been any meaningful police reform since the 1990s. And part of that is politics. In the last few administrations, there were 69 different pattern and practice investigations by the Justice Department, leading to 40 settlements or consent decrees. In the entirety of the current administration, there has been one such investigation. The results were actually published yesterday, and they determined there's been gross abuse by Massachusetts narcotics officers. But the Justice Department has completely ceased to engage on these issues, and that's politics. And that touches you as citizens, I think. As lawyers, litigation matters. In criminal procedure, that often means defense lawyering and the issues that you fight for one client having an impact on those millions of people who are encountering law enforcement officers in later encounters. It also means that prosecutors have to make choices about when the conduct of police officers should be defended by the government and what rules and advantages are worth pressing. And as I've been saying, litigation is the way to close off a lot of these pathways to violence. And there's a huge role for lawyers on both sides in the criminal justice system in addressing those issues.
So, you know, and thanks for the question, Professor McCoy. I'll say, you know, from a personal point of view, this is the second time that in my career here at Duke alone that I've been on a panel like this. We had a panel shortly after Ferguson like this, and this issue. Like for a lot of you, a lot of us, has sort of punctuated my life. So Malice Green was killed by the Detroit police when I was 10. I was, I think, in college when Rodney King was beaten by the LAPD. I was in law school when Amadou Diallo was shot by the New York Police Department. And it just goes on and on and on, as Professor Lovelace has said. And so, you know, from a personal point of view, it's hard not to be on a panel like this or see these stories and not think about encounters I've had with the police myself, which is if I had just moved a little differently, a little too fast or a little too slow, or if I had looked a little different, if I had said something just in a different way, how that would have turned out. That's just by way of saying that, you know, expressing, I think, my sense of the community sense and maybe even the nation's sense that we're just tired of this, just tired of this happening again and again, which is why the Black Lives Matter protests have been so significant. And I think in terms of your question, I'll just echo exactly what Professor Lovelace said, which is the best mechanism is the expression of these kinds of the desire for change to come through political participation and political power. The March on Washington is a incredible event, but it's just a snapshot in Life magazine without the Civil Rights Act of 1964. The march across Edmund Pettus Bridge in Selma, Alabama, is a shocking image on a screen or in a magazine without the Voting Rights Act of 1965. A few years ago, I wrote an op-ed, and I think it still resonates today, which is the real monuments to these kinds of movements aren't the placards, you know, at the corners of streets or street signs. They are the laws that come as a process of translating movements into political power and political change that makes it better structurally for everyone on this issue.
I'll just add that laws have now been introduced in dozens of states and will be introduced in dozens of others. Every single one of these legislative efforts, and there's been federal legislation that isn't moving quickly but could. Every single one of these legal battles will be hard fought in the legislatures. They will be needing to hear from lawyers. They'll be needing to hear from experts, and they'll be needing to hear from activists. Lawyers have a role to play, though, in drafting these laws and in turning them into real policy and making sure that they're followed. Lawyers will be needed to pursue civil rights litigation like we have for decades and decades, sometimes with real effect, sometimes without. We need to move the law in this area, and it takes different types of lawyers doing different types of work. It's going to take work to rethink police budgeting. It's going to take, you know, a financial look at what do we fund and what do we not fund in terms of public safety. It's going to take empirically minded lawyers to look at what kind of databases can we assemble to track officer misconduct. We can pass laws requiring it, but we actually have to do it. There's going to be incredible work to do involving really different types of skills. And whether it's tracking legislation, testifying, informing legislation, activism to highlight stories, to push the need for passing these statutes, implementing, working with local leaders to think about everything from budgets to training to, whether it's bias training, whether it's upstander training, whether it's use of force training. There's going to be really interesting work. And so as lawyers, whether your one skill set is improving organizational culture, defending, prosecuting criminal cases, finance, thinking about budgets, municipal budgeting, or getting involved in the lawmaking process. Lawyers of all different types of skills and interests can play a role in this powerful movement. And I hope that some of you decide to do that as law students or in your pro bono practices or in your careers.
Yeah, I think that lawyers just have a really unique ability to help to create the kind of change that many people are looking for. Lawyers on multiple sides of this issue must engage courts in ways in which my colleagues have talked about. Lawyers can help demonstrations by serving as legal observers. Law students can participate here as well. The question becomes, for someone who's interested really in social movements, what do you do between marches, or what do you do while constitutional litigation or civil litigation is just pending? Join an organization, right? So I think that just participating in civic life is important for lawyers. I mean, in particular for law students. Many law students are very involved in affinity groups or other organizations in the law school. When you graduate, don't forget about your participation in law school and how active you were in these organizations. And so it's important to join organizations that are interested in both legal and social change. And then again, to echo some of the earlier points about participating actively in the political process, whether this means tracking bills or drafting legislation. And I think that part of the challenge for this moment, because policy windows are often very narrow, is to have a larger conversation, not simply about the police formally, but more to Professor Miller's point about policing writ large. And then all the other systems, going to that first question that we had, that contribute to a system where many people think that we need police. So talking about systemic racism, whether it's in healthcare, whether it's in employment, and definitely as it relates to voting.
So as I move about the community, there are a lot of people who are confused about this concept of what it means to defund the police. We know that police respond oftentimes to situations that are not necessarily criminal. We've seen in cases like Tatiana Jefferson where it was simple wellness checks that went wrong. Why can't we divert those funds into social services agencies for the provision of services and the provision of wellness checks, as opposed to always deferring to a police presence? So I wanted to first kind of get your explanation on what it means to defund the police, and secondarily, if you think that it's something that will be beneficial to reducing police brutality or not.
I'll just note that if we want real social services to replace intervention by armed police officers, we need real social services. And one of the reasons why we have police intervening in lots of places where they would prefer not to be and where many would not prefer them to be has been because we don't have the resources in our schools. We deinstitutionalized and do not have adequate housing or care for people with serious behavioral health needs. And we do not have adequate housing for people with low incomes, and therefore we have people who are homeless, and then they're interacting with police. Enormous cuts to the safety net, whether it's the unemployed or for families with low incomes. We have inadequate health care. One of the most important reasons why people file civil rights lawsuits after police use deadly force, turning back to deadly force and shootings, it's because many people don't have health care when they get injured by the police. And And so, you know, we can't solve the policing problem purely by limiting the types of things that police can do, because there are real needs and those needs are not being met. And the conversation is turning and should turn from policing towards what are the social services, what are the safety nets that we really need? How can we have people who can provide support to address needs in communities who don't wear a badge, so that we can use people who wear badges to address the public safety needs that we think are most important. That's a big conversation, and it's going to require undoing, you know, 30 plus years of cuts to the safety net and cuts to social services across our country.
I'll just echo what Professor Garrett said. You know, one of the issues here, and he mentioned it, that I've often thought about in the terms of sort of defund the police, is the phenomena of what happened in the 60s with the deinstitutionalizing of the mentally ill. The sort of throwing open the doors of the mental institutions was easy. The hard part, which never got done, was supplying the social services necessary to help people who are mentally ill and could not take care of themselves. And that part was totally forgotten. So I think a really important part of this conversation that Professor Garrett has quite rightly said is, you know, the sort of taking the money away is easy. The important part, or it's easier now, I should say. The important part is, you know, supplying the alternatives of what the kind of social services that we're demanding of police now to provide, that they're not in a position to provide very effectively.
Now, I want to shift the attention a little bit. One of the things that we saw, particularly after the Rayshard Brooks murder, was body cam footage that actually showed when the officer who engaged in the shooting went to talk to another officer, and he was instructed, call your union rep. So this concept of police unions, what do they do, and how do we deal with the police unions in trying to achieve justice?
Well, some of the litigation I worked on as a young civil rights lawyer involved cases just like that, where you'd have union reps and lawyers shuttle officers from the scene of a shooting and basically get them together, prep them, get their stories straight, making it very difficult to do meaningful investigation into what happened. Body cams have changed that. It was harder when you were depending on the word of the survivors of an incident to find out what really happened and whether discipline or liability should result. Interestingly, though, I mean, lawyers played an important role in some of that. There was litigation naming the police unions in New York City as civil rights conspirators for promoting a wall of silence that made it difficult to investigate police misconduct. And so important reforms were obtained by actually naming police unions under the Ku Klux Klan statutes, which was remarkable and creative lawyering. But you know, all too often, police reform has been stymied because of contracts that the cities have been willing to enter with police unions. They don't have to enter those contracts, right? They can insist that the conditions governing employment of police officers be fair, but also reflect the public's need for transparency, for protection of civil rights, and for information about what police officers do, including police misconduct. And I think that's going to start happening as these laws are introduced, to say, look, we need to certify police officers. We need to collect information about non-deadly use of force, not just deadly use of force. We need prompt investigation within police departments firsthand. We can't rely on informal backroom type of discussions to resolve the most serious allegations of misconduct that we have in this country. And I think it's unfortunate that there's been this tradition of deference to this informal, we'll work things out between the union lawyers and the policing top brass in the past. But that has to end. And I think because of public pressure, because of the protests, that role is gradually being eroded.
So it looks like we are running short of time. I wanted to make the floor available for all of you to give a 1-minute closing statement about kind of what you feel about what should be done moving forward.
This is an incredible moment, really just unprecedented in all of our lifetimes. I think that, you know, when you look at the history of racial reform in America, again, these windows are very small, right? So after Reconstruction, redemption happens soon thereafter. If you have something like Brown versus Board of Education, massive resistance sets in. That even if you think about the, 2008 election and then the 2016 election, right? We have to understand the rise of Donald Trump in many ways as backlash to at least perceive racial justice with President Obama. We have many interests converging right now at this point in time. And so seize the day, really seize the day.
I just wanted to briefly emphasize there's some great questions that we can't answer all of, that some of these deep changes that are contemplated to policing are important both to protect people's civil rights and for fairness, but also to accomplish public safety. That more and more research has been done to document what people have long known, that a lot of this low-level enforcement engenders crime. It's actually crimogenic. We've seen that in the area of bail, that holding people in jail so that people lose their jobs, lose their income, lose their housing, causes crime. It does not protect public safety. That imposing burdensome debt on people, even in petty offenses, harms communities, causes crime, does not protect public safety. And so we can protect public safety and improve policing in this country. We can improve the jobs of police officers and improve policing in this country. I think that's one of the reasons that this has become a bipartisan issue. There's broader understanding that throwing police at social problems, throwing people into cells to solve social problems is not a solution. It doesn't accomplish public safety. It's expensive. It horribly damages communities, harms people's rights. And there are good solutions that there's been some experimentation with, but there has not been broad adoption because of protest, because of social movement, because of so many years of struggle. We really are, I think, at a tipping point. And this is an incredibly exciting time to be a lawyer and to be working on these issues and to care about these issues. So really excited to see what comes out of this incredible moment in our history.
I want to agree with what Professor Garrett said about the harm to public safety from a lot of our policing. When it comes to defunding police, there are a lot more nuanced ways that you could say that, but there's no question that we can be spending less on public safety that is not working and more on social services that are sorely needed. And that is one obvious place to start. The place where this all started in some respects, I mean, obviously it started hundreds of years ago, but what brought us here today, I think in many respects, is the raw savagery and the sheer inhumanity of the murder of George Floyd. It's definitely changed the conversation. It's increased momentum on all of these things that we've been talking about. And when you think about that incident and other incidents like it, and there have been far too many, it's easy to say nothing is going to fix this that is broken beyond repair. And I think that's true with respect to some of the violence that has occurred, but I don't think that it is true with respect to the entire system that we have. many, many things are broken. Policing, yes, first and foremost, because it leads to this kind of brutality, but also housing and jobs and healthcare and education and voting rights. But all of these episodes and instances of structural inequality that come to the fore give us opportunities as lawyers to try to address them. And I think that lawyers have an obligation to do that. So some things are broken and can't be fixed and need to end. And that includes significant aspects of the kind of policing that we have now. But some things can be fixed. And I think the most important takeaway from what I've been hearing from my colleagues today and been thinking about and preparing for talking with you is that I really want to convey that it does not have to be this way. We don't have to just throw up our hands and say, this is how policing has always been. We do need to excise the parts of it that are damaged and no amount of training will ever fix. But there are parts of it that we can address as lawyers. We can change these rules, we can change these standards, and we can insist on a more just system. And it seems more within grasp right now, and I, like Professor Miller, have been on many of these panels over a decade, but at this moment, it seems more within grasp than it ever has before, even though it's an incredibly painful moment, and there's a lot that we have to face and understand in order to get there.
So I think I would just sort of talk about or reiterate sort of what I've said with this addition, which is all social movements throughout American history have always sort of run on at least two tracks. There's the social activism track, there's the legislative policy making track, and then there is the sort of purely legal constitutional track, whether we're looking at things like rights for same-sex marriage, or we're looking at the civil rights era in the 1960s. I think understanding that there are sort of lanes, and these lanes influence each other is an important component that lawyers in particular can understand. Before the 1980s, in some jurisdictions, it was still lawful to shoot a fleeing felon in the back. Small changes in police departments changing their rules ended up influencing Supreme Court practice and Supreme Court law on the Fourth Amendment on that issue. Now that is not constitutionally allowed. It happens, but as a constitutional matter, it's a potential source of liability and therefore a constitutional norm that is not acceptable behavior. And if we see these things as interrelated, as running in different lanes but interacting, and if we seize the moment with coalitions, with political participation, with making sure you get out and vote, we can really see change happen as we've seen before.
Well, I'm sure we could have this conversation go on forever. I think the one thing that I do want to echo is there is a large portion of our student base and faculty who not only can discuss and talk about issues of police brutality, but who have also personally lived through police brutality. So I don't want any of our students who have been through that to ever feel like you're alone. As always, I am in room 1173 if we ever get back to campus. So please feel free to stop by and we can certainly talk about that. We've reached the end of our program. I would like to thank Dean Abrams for hosting this program, Stella Boswell, the Assistant Dean of Public Interest and Pro Bono, for her efforts in organizing the program, and most importantly, our outstanding panelists for sharing with us their expertise. Finally, I would like to thank all of the attendees who joined us today. I hope that we were able to address and explain at least some of the issues that you've been seeing on your nightly news. And I apologize if there were questions that we just couldn't get to just due to the time constraints, but please note that we will be posting links with additional resources and information that you can view at your leisure. So I just want to thank you once again for joining us. Thank you again, panelists, and everybody have a great afternoon.